Time now for our Ask the Lawyer segment, and joining me now is New Haven-based attorney Tara Knight. Glad you're with us tonight.
Thank you, Ann.
And tonight we're taking on the topic that's been in the headlines in the past week: sex scandals involving teachers. On Friday, we learned of a New Haven teacher being arrested, charged with having a sexual relationship with a student. And the day before that was the Choate report that came out saying that former teachers at Choate, 12 of them, were accused of abusing students dating back to the 60s. The school admitted that that happened, yet there have been no charges filed. So we're talking about the 60s. Tell me a little bit about the statute of limitations.
Right. It's not that unusual in institutional cases where there's allegations of abuse, especially of young people, that no charges get filed. And there's a host of reasons why young people keep it to themselves. There's an authority divergence, and there's fear. In any event, the legislature recognizes that, and recognizes that people might not come to realize the ramifications of abuse until they mature, until they get older. So they extended the statute of limitations, where a typical felony might be a 5-year statute of limitations. With sexual abuse, it's 30 years from the date you reach majority. So that means when a person turns 18 years old, they have 30 years within which to potentially sue.
That's a significant amount of time. And are we talking about, could they be criminal charges as well as a civil lawsuit against the school and the teacher?
Yes, likewise, the criminal statute is also the same thing. It's, generally speaking, there are some exceptions that I won't get bogged down in, but it's 30 years from the time a person reaches majority. Additionally, if the abuse occurred when a child is very young, it's 5 years from the time the child, or even adult now, tells a police officer or a prosecuting authority of the abuse.
So how difficult is it to prosecute one of these cases, especially when you're talking about going back as much as 30 years?
It's extremely difficult because as time passes, memories fade. There isn't physical evidence in the case of DNA. Witnesses die or move away. So it's very difficult. So prosecutors and plaintiffs' attorneys who are suing on behalf of people abused have to look to other corroborating evidence that's not as readily available.
And plus, as you were saying, memories. You think, well, if this person never reported it. In the Choate case, none of the students came forward and actually went to the police to say that these had happened, so I'm sure they look at that as well.
Right, and defense attorneys make a lot with that, the fact that it's never been reported. So what the prosecutors and the plaintiff's lawyers do is they look to other evidence. For instance, did the victims tell anybody else at the time? That's a brand of evidence called constancy of accusation. If someone told a friend or confided in their family members, that can actually be brought out and is not considered hearsay in court.
So let's talk about the New Haven case that came up on Friday for a teacher, and we have no idea if this teacher is guilty or innocent, but let's just say if a teacher finds himself in that position being accused of a crime, how do you prepare them for that, and what's the defense in that case?
Well, generally, I don't know in that particular case what the defense will be, and just a disclaimer, I do represent the victim in that case.
Okay.
Having said that, generally speaking, what you do is you'll look to find reasons why someone might be not telling the truth or might not be credible, or if there's inconsistencies in the story. Generally, a defense attorney will do that. Generally, a defense attorney will look to see what statements the complainant witness has given to see if there's inconsistencies or if there's a motive to lie or fabricate the allegations.
And unfortunately, we hear more and more types of these things. And when you talk about abuse, so much of it is on social media and Twitter and Instagram and that type of thing. Is there a fine line between a teacher communicating with a student and crossing that line? Is there a gray area, or is it pretty black and white when it comes to the court?
Well, it's the pendulum is swinging to the point where, you know, it's even if you're of an age to consent. 16 years old is the age of consent in Connecticut. Even if you're 16 years old, you cannot have a sexual relationship with a teacher because, again, the legislature has recognized that there's a power differential, that there's fear that can be imposed on, or intimidation imposed on a student. So even though you're technically on the age of consent, you can go and have sexual relations with another adult. You cannot have that with a teacher, you know, or a coach, anyone in that kind of authority position.
Okay, well, thank you for your insight tonight on this topic. Good to see you as always.
Thank you.
And if you'd like to see more on this segment, you can find it right there on our website at WTNH.com.